probation order is referred to as a community-based order. This means the order allows you to remain in the community as opposed to being sent to prison. Courts can use a probation order as an alternative to a prison sentence or with a prison sentence. This means you may be sentenced to a term of imprisonment, and when you are released from prison, you are subject to a probation order. If you are sentenced to a probation order, you'll be supervised by the Department of Corrective Services in the community. The court can only make a probation order if a person is sentenced for an offence punishable by imprisonment or for a regulatory offence. A probation order can only be made if you agree to the conditions of it. The magistrate or judge will read out the conditions of the order and ask if you agree to abide by them. The probation order will be for a defined period. If you are not sentenced to a prison sentence and probation, then the minimum period the order can be for is 6 months and the maximum is 3 years. If you are sentenced to a prison sentence and probation, then the minimum period of the order is 9 months and the maximum is 3 years. Now, you might be wondering, is a conviction recorded for a probation order? If the court makes a probation order, the court does not need to record a conviction. So, what are the conditions of a probation order? The mandatory conditions of a probation order are: you must not commit another offence. You must report to an authorised corrective services officer at the place and within the time stated in the order. You must report to and receive visits from an authorised corrective services officer as directed by that officer. You must take part in counselling and satisfactorily attend other programs as directed by the court or an authorised corrective services officer during the period of the order. You must notify an authorised corrective services officer each time you change your home address or where you work, and this must be done within 2 days after the change has been made. You can't leave the state of Queensland without the permission of an authorised corrective services officer. And you must comply with every reasonable direction of an authorised corrective services officer. The court can include any other conditions it thinks fit in order to try to cause you to behave in a way acceptable to the community, prevent you from committing the same offence for which you were sentenced to the probation order for, to prevent you from committing more offences. If you have mental health issues, the court may make a condition for you to complete counselling with a psychologist or psychiatrist. Now, what happens if you breach a probation order? If you do not comply with the probation order and you do not have a reasonable excuse, you can be fined. In addition to being fined, you can return to court and be sentenced for breaching the order. This can involve you being resentenced for the offences for which you were originally placed on the order. This means the court will give you another penalty. When resentencing you, the court must consider your compliance with the probation order when deciding on the new penalty to give you.